Hello, everyone, and welcome to the program. This is Sunday Politics live on Channels Television. I am Kayode Okikiolu here in Lagos. Well, it's the last edition of Sunday Politics for 2019, an election year that lived up to its expectation as being politically charged. We're counting down to the year 2020, and while everything seems a bit quiet and relaxed, make no mistake, because politics hardly takes a break. So the next year is also shaping up to serve us with its own fair share of intrigues. And while we continue to anticipate the coming year, let's take a look at one of the revelations that caused and is still causing a major controversy in the nation's polity. Well, it's about a certain 37 billion naira, which has been budgeted for the renovation of the National Assembly. Well, the news was welcomed with uproar from Nigerians who wondered, that much money, why is it being budgeted for the renovation of the legislative complex when a major infrastructure deficit persists in the nation? So some organizations have taken this rejection a step further by going to the court of law to have this move thoroughly reviewed. The Socioeconomic Rights and Accountability Project, SERAP, budget Enough is Enough, and 583 concerned Nigerians are said to have filed a lawsuit asking the Federal High Court Abuja to restrain and stop President Muhammadu Buhari and Minister of Finance, Mrs. Zainab Ahmed, from releasing the 37 billion naira to the Federal Capital Development Agency and the National Assembly until an impact assessment of the spending is carried out. Well, the groups are also seeking a court order to restrain, prevent and stop the Senate President Ahmed Lawan, the Speaker of the House of Representatives Femi Gbajabiamila, and the FCDA from demanding or collecting the 37 billion naira, which was earmarked for the renovation of the National Assembly complex, until an impact assessment of the spending on critical sectors and access to public goods and services is carried out. In the suit, which was filed last week at the court, the plaintiffs argued that spending 37 billion naira to renovate the complex is self-serving, wrongful, illegal and unconstitutional expenditure of public funds, as it means less money for educating millions of out-of-school Nigerian children, providing access to clean water and healthcare to Nigerians, including elderly, or repairing the country's roads and bridges. Well, the 583 concerned Nigerians who joined the suit as co-plaintiffs include Bring Back Our Girls co-convener Aisha Yesufu, Nigerian singer and actor Banky Wellington, amongst others. Well, at this point, no date has been fixed for the hearing of the suit, but that is one case Nigerians might be following very closely. So now that SERAP and other concerned Nigerians have taken this matter to court, the attention now turns to the judiciary to see how this is handled. The judiciary is a very vital part of any society because of its role in ensuring that justice is not just done, but also seen to be done. And it's interesting to note that as we count down to a new year, the judiciary is perhaps way ahead of us because they entered into a new legal year as far back as September. Well, that's the 2019-2020 legal year. And at the event marking the transition, Justice John So, while giving a review of the previous year, said that 12,694 out of the 16,144 cases brought before them in the previous legal year were dispensed with, while there are still 116,623 cases pending at the court. Now, that's one issue. The other one is the role of the judiciary in protecting human rights without prejudice and ensuring that the arms of government responsible for enforcing these rights do their work. Now, add to that some other big stories that touched on the judiciary this year. Our year 2019, that is, not just the legal year. So let's take a look at these issues. And, you know, we're being joined by a senior advocate of Nigeria, Mr. Jibrin Okutekpa, who helps us to take a look at the human right quotient of the country, how we have handled this, and some other major issues that came up during the year 2019. Good evening, and thank you for joining us tonight on the program.
Good evening, my brother. How are you?
I'm doing great, and compliment of a season to you. I see you started off by smiling. Perhaps you want to share with us what made you smile there.
Well, I'm smiling because when we talk about the rule of law in this country, it appears to me, as a lawyer, that it's being observed in breach rather than in obedience. And the arm of government that is responsible for giving directions and order for the observance of the rule of law, which is the judiciary, seems to be incapacitated by deliberate sabotage of that arm of government by the other arms of government. And what do I mean? When you look at the judicial arm of government, it is the arm of government by virtue of Section 6 of the Constitution that is responsible for settling disputes between other arms of government, between persons and other authorities in this country. But it requires patriotic and commitment of the executive for orders of the judiciary to be enforced and to be obeyed. Because the judiciary, for instance, does not have the coercive power, so to speak, to enforce its orders. It's only to give orders. And once this order is given, it requires obedience on the part of the other arms of government to obey. And mark you, the judicial arm of government is the only arm of government that is not expected to belong to any political party. The two other arms of government are partisan members of Nigerian society who may either belong to APC, PDP, Accord Party, or any other party.
Right.
And mark you that in Nigeria, politicians seem to be interested in their selfish, primordial partisan interests than nationalistic interests. So when orders are given by the judiciary, the executive is the one to enforce that order, because executive arm of government is the one that is responsible for the enforcement of court orders and execution of that order. So I'm smiling because it appears to me that in this country, we seem to play politics with so many things, including human lives. And so I believe that if we are talking about the rule of law and assessing a Nigerian government, even from the time we got independent to date, there are so many hiccups here and there. And on daily basis, the disobedience to court order is assuming a proportion that is a geometrical one.
Right, Mr. Okutakpa, if I may come in now. You know, some might say that,
yes.
Just pardon me, some might say that, the judiciary is not entirely powerless when it comes to obedience of court orders. And I'll cite an example. You recall when Justice Ijema Ojukwu ordered the DSS to release Mr. Shore within 24 hours. Now, that was a major one, and people thought, apparently, the judiciary can actually take this battle a step further. So, this is an example for one, and there are other issues, there are other examples. So would you say the judiciary is still perhaps powerless when it comes to that area?
Now, when it comes to enforcing the order of the judiciary, yes, you have cited an example of my Lord, Honorable Justice Ijoma Ojukwu, who gave order that the order should be obeyed within 24 hours. And you could see the judiciary the executive obeying that order in breach, because the moment there was an attempt to obey the order, you could see, and you all are witnesses to, how that order was obeyed in breach, because the person who was ordered to be released was released. And in the first time in Nigerian history, the hallowed chambers of the court was invaded by those who are paid to protect us by the taxpayers' money, using the guns to invade the court. So it is unprecedented for the hallowed chambers of the judiciary to be enforced. To be invaded by the other arms of government who are supposed to pay obedience to the orders of the court. So my take on this matter is that the two arms of government who are supposed to pay obedience and respect to court orders are in most cases exhibiting what I may refer to as a tainted partisanship. The judiciary is not like that. The judiciary is blind. It does not care who comes before it. Its duty is to give orders.
Right.
And once this order is given, certain arms of government, executive is to obey it. So we must get to how the judiciary itself must ensure that its orders is not obeyed in breach. And I will talk in respect of that as time goes on in this program.
All right. So we'll get to that in a moment. We'll get to that in a moment. But I'd like to also, have an understanding of an inside view, because I believe members of the judiciary across the bar and the bench, you have candid conversations with one another about the nation's judiciary, and that's away from the classic courtroom battles. So I'd like to know, when you talk about the year 2019, because before we come back to this human rights issue and obedience to court order, what is your honest assessment of the judiciary? Now, this is not the judiciary in relation to enforcement agencies, the judiciary.
Now, if you ask me to assess the judiciary, and in terms of being a teacher to give marks, I will say that the judiciary in Nigeria, despite the excruciating environment and unhygienic environment in which they functions, I think they have discharged their jobs creditably well. And if you ask me to give them marks in terms of performance of their jobs, I think they scored above 60%, notwithstanding that we may not agree with some of the decisions that they have dished out. Some of the decisions, some of our colleagues have rightly, in my estimation, describing it as giving judgment without justice. And I will explain this when we get so much to it. But because of the volumes of work that the judiciaries in this country had been trusted to cope with, for instance, in both pre- and post-election matters, the judiciary has been conscripted, permit me the use of the word, to work within the given limit under the Constitution. Section 285, for instance, of our Constitution has now given the judiciary, the bar and the bench, if I may say, 180 days from a trial in pre-election matter and post-election matters, 60 days at the Court of Appeal, and the 60 days in the Supreme Court. And I witnessed about 2 weeks ago that the Supreme Court of Nigeria, that constitutionally, they are not supposed to be more than 21 justices of that court, and they have never had even their full complement of 21 justices, had on the court list in one day 15 gubernatorial appeals in that court. And mark you, in the Supreme Court, these wise men and women in that court, none is below 50 years. There are above 60s.
So, Mr.
And we're
Akutepa,
expecting them to read
if I understand you clearly,
of appeal.
If I understand you clearly, pardon me, so this challenge that you talk about, where is it coming from? Because, I mean, you have reeled out some of these issues. In fact, just as John Soho said, at this moment, about 100 and, just one moment, about 116,000 cases are still pending in courts across the country. So is this something that stems from the judiciary or outside the judiciary? Because we need to understand where this challenge comes from if we want to solve it.
If you want to solve it, first and foremost, we need to understand that the judiciary is understaffed. For instance, in the Supreme Court, the Constitution says we should not have more than 21 justices of that court. And we have not had up to that 21. I'm not too sure whether we have had 21 justices of Supreme Court. And appeals come from all the divisions of the Court of Appeal to the Supreme Court. And these justices of the Supreme Court, as I speak with you, still write with long hand. And Nigeria is the only country in 21st century that still practice Stone Age in judicial proceeding, taking notes. So there is a deliberate sabotage, so to speak, from the part of the other arms of government, the legislature, for instance. For instance, we have about 109 senators in the National Assembly and about 400 and something in the House of Representatives. Meanwhile, the Supreme Court of Nigeria, which is the highest court of the land, has, by constitutional limitation, only 21 justices, and we have not gotten the number of justices of that court. So I had said before, and I want to say tonight, that if we want justice to be quickly dispensed in the Supreme Court, then we must have the equivalent number of justices of Supreme Court as we have in the Senate.
Right.
Equivalent number of members, justices of the Court of Appeal as we have in the House of Representatives. Then go down to the states. The state houses of assembly has a number of members of House of Assembly. And I also recommend that High Court judges and Federal High Court should take equivalence of those members of the honorable members of the House of Assemblies.
Right.
Meanwhile,
so,
I also
Mr. Akutepa,
recommend
on
that
one
the
hand,
same emoluments
okay,
paid
right.
to them should be paid to judges.
Right. So I just want to understand. Now, these reforms that you were talking about, where would it start from? who should initiate it?
It should
Who is
start
meant
from
to
the
take action on it?
The legislative arm of government must amend our constitution to give rooms for more judges, to give rooms for more pay. And in the recruitment of these judicial officers, we must also have at the back of our minds people who have the character and quality of the people I may refer to as Joseph and Daniel of our time, who may run away from Potiphar's wife when they are tempted. We must have Daniels who may not want to defile themselves with the king's wine and meat. In other words, we must have judicial officers of impeccable characters, those whose character is above board, like Caesar's wife.
Right.
So the reform must start from the legislature and with collaboration with the judiciary. Then we now have a balance where the kind thing we have today, where the political class, permit the use of this word I want to use, have hijacked the judiciary by now conscripting the judiciary to handle matters that are only purely political. There are other commercial cases that are lying because the judiciary, by constitutional provision, have now been made to only hear political cases within a given number of times, and they are devoting their time to hearing it.
Mr. Okutekpa, are you implying that the judiciary is subservient to the political class? Is that what you're saying?
I'm not saying so, but by operation of law, it appears to be so. Because the judiciary is meant to to interpret the law and follow the law. Now the Constitution has set out the number of days cases of political nature must be concluded. Nothing is said about cases of commercial nature. Nothing is said about tort. Nothing is said about breach of contract. Nothing is said about even criminal matters. We have Administration of Criminal Justice Act, but there is no time frame that is in the Constitution dealing with the criminal matter. So my take is that we must be holistic when we come to giving justice to Nigeria.
Right.
The kind of partisan kind of amendment of our laws that is inclined towards political aggrandizement of our politicians must stop. Let us amend our laws to cut across board so that every Nigerian must get justice in our court at the same time with the same number of time and dates. Not that an appeal filed today will be heard in 2030 in a civil matter, whereas in political matters, 180 days is finished. 60 days,
Mr. Okutekpa,
Supreme Court, and our judiciary is overworked.
Understandably. Now, some have described this as a classic case of a doctor that has a headache. I mean, it's ironic for you to actually reel out some of his challenges. I mean, it's the judiciary, a major arm of government. And I'd like you to talk about the fact that this is not the first time we've heard of this, these ideas, these reforms, these issues you have put out there. I mean, they have been talked about time and time again, but still, we're in the year 2019, moving on to the year 2020, and we're still talking about this. And the challenge for me, or I think the worry, is that by the year 2020, maybe this is still what we will be talking about. But we'll have to go on a break right now, Mr. Okutekpa, and allow you gather your thoughts. And when we return, we'll take a look at this issue. We'll also talk about the funding of the judiciary and the fact that you talked about the judiciary is understaffed. How do we ensure that we don't continue this cycle year in, year out? Join us again. Well, you're welcome back to the program. We're still talking about the rule of law and the judiciary in the nation. We're still being joined by Mr. Jibrin Okutekpa, who is a senior advocate of Nigeria. He joins us from our Abuja studio. Thank you so much for staying with us. So before the break, I wanted you to tell us how this one will be different from the previous reforms and ideas we have brought up in the nation. I mean, we don't want to continue with the same cycle. So what should we do differently this time around?
I think, Kayode, Nigerians need to demand responsibility from our government. And I'm happy in the intro, I saw that Serap and other Nigerians have gone to court to demand that the whooping sum of 37 billion naira for renovation of National Assembly be not used and wasted on so-called renovation. I think time has come when Nigerians will begin to make a demand of government that the judicial arm of government, which cannot talk, it can only talk in judgments. It doesn't have the mouth organ of its own that you have the Ministry of Information for propaganda. So the legal profession and all Nigerians must demand that Nigeria get justice in our court. Because when you go to our courts, you will discover that a matter that is filed today, unless it's politically related in pre-election and post-election matters, may take the next 10 years. It may not have taken off. And it's deliberately done so by the legislative and the executive arm of government so that the quality of judgments we need that will give justice to our people will not be there. Because
Right.
most of the times, what you get from our court are judgments that may not really take into account justice of the matter. Because the volume of work that the judiciary is confronted with the kind of manpower, we need to amend our laws, increase the number of judicial officers across board,
Right.
increase their emolument, make their working environment conducive. Now, Nigeria judges still write in manual longhand. You go to court, even though we do what we call front loading today, judges still record evidence and cross-examination in longhand. They sit down to write, and sometimes from morning till night. And in one day, you may have a cost list that is up to 20 to 30 cases on the cost list.
So,
and